appeal, Secretary of State for Foreign and Commonwealth Affairs, and another against Yunus Rahmatullah.
Lord Wilson will announce the judgment.
Mr. Rahmatullah, a citizen of Pakistan, is currently held by US forces in a detention facility in Afghanistan. In February 2004, British forces captured him in Iraq and handed him over to US forces there, who soon removed him from Iraq to the facility in Afghanistan. The US authorities believed that he had links with Al-Qaeda. In these proceedings, Mr. Rahmatullah has sought the issue of a writ of habeas corpus against the Foreign Secretary and the Secretary of State for Defense. A writ of habeas corpus is an order against a respondent who is detaining another person or has control over that person's detention. Technically, it requires the detained person to be brought before the court on a future date, but the court will usually be content if, on that day, the respondent establishes that the person's detention is lawful. If the respondent fails to establish it, the court will order the person to be released. On 14 December 2011, the Court of Appeal, reversing the decision of the court below, ordered that a writ of habeas corpus should be issued against the two Secretaries of State in relation to the detention of Mr. Rahmatullah. The Secretaries of State now appeal against that first order of the Court of Appeal. On 20 February 2012, the Court of Appeal examined the contents of two letters written following its first order. The first was written on behalf of the Secretaries of State to the US Defense Department, dated 16 December 2011, in which they sought the transfer of Mr. Rahmatullah back into the custody of the UK authorities so that he could be released. The second was a reply, dated 8 February 2012, in which the US Defense Department explained why, in its view, its detention of Mr. Rahmatullah was lawful. In the light of that exchange of letters, the Court of Appeal decided to make no further order against the Secretaries of State in relation to Mr. Rahmatullah. The effect was to bring the proceedings to an end. He now cross-appeals against that second order of the Court of Appeal. This court unanimously dismisses the appeal of the Secretaries of State against the first order. It holds that when that first order was made, there were sufficient grounds for considering that the UK government might have control over Mr. Rahmatullah's detention by the US to justify the issue of the writ, so that its control or otherwise over his detention could more clearly be perceived. These grounds were twofold. The first was a memorandum of understanding between the US and the UK forces, signed and dated 23 March 2003, which was 3 days after they had both begun military operations in Iraq. Although it was not legally binding, the memorandum provided that if the UK transferred custody of a detainee to the US would return him into the custody of the UK without delay upon request, and that it would not remove him from Iraq save by arrangement with the UK. Although in 2004 the UK authorities had become aware that the US authorities intended to move Mr. Rahmatullah to Afghanistan, there had been no arrangement between them to that effect. The second, which some members of the court consider to have less impact upon the precise issue, was the Fourth Geneva Convention, dated 12 August 1949, relating to the protection of civilians in time of war. There were substantial grounds for considering that Mr. Rahmatullah was entitled to the protection of that convention, that his continued detention by the US was in breach of its terms, and that, because it had transferred him into the custody of the US, the UK was, according to its terms, itself under a duty to remedy the breach and to request his return. By a majority, this court dismisses Mr. Rahmatullah's cross-appeal against the second order. The majority accepts that there were shortcomings in the letter from the US Defense Department dated 8 February, in that it did not address either of the grounds on which the UK appeared to have a right to demand his transfer back into its custody. But, in the view of the majority, the Court of Appeal was entitled to treat the letter as a refusal by the US to transfer him back to the UK, and therefore to consider that it had become clear that the UK government did not have the control over his detention which would have justified some further order against it.
Thank you.